Do my fellow commissioners have any corrections to the minutes?
I think on page 3, the last paragraph, second line, it says Ms. Long. I think it should be
Yeah,
Ms.
it's gonna be
Lord.
real brief and
correct.
be handed right
I
over to
was
you.
going to make that correction.
Okay. I know the background, but I'm not.
I don't think so. That was the bottom of page 3 on the minutes, the last paragraph, second sentence,
Do they all understand that?
Yes.
providing documents to Miss Lord,
Rachel.
not Miss Long.
How's it spelled, please?
Do we have any other corrections to the minutes? Seeing none, can we have a motion then?
I'll make a motion to approve the minutes for July 23rd, 2001 with corrections.
Second.
We have a motion with a second. Please poll the commission.
Commissioner Bailey. Commissioner Carter.
Aye. Oh,
I'm sorry, Chairperson Carter.
aye.
Commissioner Maine.
Aye.
Commissioner Mengelberg. Commissioner Orzen.
Aye.
Commissioner Surratt.
Abstain.
And that was moved by Commissioner Orzen and seconded by,
Commissioner Maine.
thank you. All right.
Okay, this evening we have 2 hearings. We have a continuation of a variance 99-07, a remand of LUBA 2000-125, city application 00-03, and we have conditional use permit 01-02. And as you may be familiar, we have our legal stuff that we need to read at the beginning of these hearings, so please bear with me. We have the 2 public hearings on land use applications tonight, and a staff report has been prepared for each application and has been made available 7 days before tonight's hearing. The staff report identifies the approval criteria that apply to each applicant's proposal. If anyone would like me to read those criteria, please let me know. Staff has analyzed the criteria which are contained in the staff report along with written comments and input received through the public notification process for each application. The quasi-judicial hearing procedure that the commission will follow is set out in state law and the Oregon City Municipal Code. The hearing procedure steps are shown in the chart over here. Anyone wishing to speak should fill out one of these yellow forms, which I believe is on the table over there, and give it to city staff. Any letters, reports, or pictures must be marked as an exhibit by the planning staff before they are submitted into the record. For the public record, please begin all testimony stating your name and address. Testimony and evidence should be directed toward the applicable approval criteria. If you believe other criteria apply in addition to those addressed in the staff report, identify and discuss those criteria and explain why you believe they apply to the application under consideration. A person does not have to testify in order to submit written materials of any length while the public record is open on each application. However, any party wishing a continuance or to keep the record open must make that request before the public hearing is closed. If the Planning Commission makes a decision with which you disagree, any issue which you may wish to appeal must have been raised for the Commission's consideration. Without raising the issue on the record with sufficient specificity and accompanied by statements or evidence so that the city and all parties can respond, the issue will not be adjudged appealable to the State Land Use Board of Appeals. In addition, ORS 197.796 requires us to announce the following. The failure of an applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government and/or its designee to respond to the issue precludes an action for damages in circuit court. And I will ask at this time if any of the commissioners have any ex parte contacts, conflicts of interest, or bias. We will be hearing first VR 99-07. Any conflicts with that? Okay.
Any challenges from the audience to the bias or conflicts?
With our public hearing procedure, the staff report is up to 15 minutes. Applicant's presentation up to 15 minutes. Public testimony from individuals would be 5 minutes. Testimony from a group or representing a group would be 15 minutes. And we do have a code of conduct that the Planning Commission tries to adhere to, and that would basically be that all parties will be treated with dignity and respect, and all testimony will be heard fairly and open-mindedly. So with that, we will go ahead then and open the hearing for VR 99-07, the remand from Luba, on the James McKnight variance at 161 Barclay Avenue, Clackamas County map number 2, 2E31 DC, tax lot 5,400. The variance would be to allow a reduction in lot depth from 100 feet to 80 feet. And this is a quite long continuation from the original application that I believe was last August or something to that effect. So.
Thank you, Chairperson Carter and members of the Planning Commission. I'll give a very brief staff report because I'm sure you're all aware of the history of this file, and then I'll turn it over to the city attorney for some additional comments. As you're aware, you did hear this file in April 10th, 2000. Your decision basically was to uphold the staff decision, which was to deny the request for the variance. That decision was subsequently appealed to the City Commission, which overturned your decision. And that decision was then appealed to Luba and then subsequently sent back to the City Commission, which then sent it back to you again. So I think those are the basic facts of this variance. I think the City Attorney has some additional comments to make, and then you can open the public hearing.
Okay.
Mr. Cosgrove did give an accurate history of what's transpired to date. What we have before us today is a fairly limited, or it's actually limited to two questions, a fairly limited portion. This is not the straight, is a variance appropriate or not. Luba affirmed on 3 out of the 5 variance criteria, and nobody challenged that. So those are considered that they have been met, and that leaves only OCMC 17.60.020C and F. C involves whether the applicant's circumstances are not self-imposed or merely constitute a monetary hardship or inconvenience. A self-imposed difficulty will be found if the applicant knew or should have known of the restriction at the time the site was purchased. And F involves whether the variance conforms to the comprehensive plan intent of the ordinance being varied. On the first one, C, involving whether the circumstances are self-imposed or merely constitute a monetary hardship, Luba said that the city's findings did not address the second prong of that criterion, that they do not merely constitute a monetary hardship or inconvenience. As to the second one, Luba, the city's decision noted that the application furthered the intent of the comprehensive plan by including infill and higher density. And what Luba said is there's nothing wrong with that, but you've got to identify the comprehensive plan provisions that come from that if you're going to make that finding. So what you have before you is, does the variance conform to the comprehensive plan and the intent of the variant ordinance being varied? And those are really the two questions that you have. And if you have any questions of me, I'll be happy to attempt to answer them. And then you can move forward with the public hearing.
Okay. Do commissioners have any questions of Mr. Kleisman?
And we'll certainly be available to help you out as things go along in this. So.
Okay. Well, thank you very much. So we would be ready then to go ahead and open the public hearing and have the applicant come forward.
Good evening, Madam Chairperson, Commissioners. My name is Jill Long, and my address is 101 Southwest Main Street, 15th floor, Portland, Oregon, 97204. I am here representing Jim and Diane McKnight, who are the applicants in this variance application. The city manager and city attorney did an excellent job of providing you with the history of the application, so I will not repeat there. I'll just move into criterion C and criterion F that Luba has remanded. Luba's decision made clear that everything that the City Commission had adopted in its findings was proper and accurate, and that the only things open for discussion were Part 2 of Criterion C and the comprehensive plan sections of Criterion F. First, I'll address Criterion C. With LUBA's interpretation that Criterion C is a two-pronged test, we must talk now about whether or not the hardship suffered by the applicant is a merely financial hardship or inconvenience. The hardship that was determined to have been suffered by the applicant in the City Commission findings was the history of the application, the unusual history of the application. And that history included a pre-application meeting in August of 1998, wherein the applicant was told that the city code may be changing in the future, but because his pre-application process had begun, that change would not affect his partition application. This was actually a partition application originally. No variance was required because the lot depth of 80 feet was an outright allowed lot depth under the code. The applicant then, and excuse me on the dates, I'm going to be general in there, around January, after his August pre-application meeting, asked for an extension and was told that he would now have to apply for a variance. This history provided some unusual circumstances and a hardship to the applicant. He relied in good faith on the information given by the city planner, and the City Commission found that this reliance in good faith and this misguidance was a hardship he suffered that precluded him from moving forward with the property right he had at the time of the pre-application meeting. This is not merely a financial hardship. It's the loss of a property right. It's the loss to move forward as he understood from the city planner that he could at the time of the pre-application meeting. These circumstances provide evidence that prong 2 of Criterion C has been met because these circumstances are a hardship suffered by the applicant that are not merely financial and not a mere financial inconvenience. The second question remanded by LUBA was dealing with Criterion F. Criterion F states that the variance conforms to the comprehensive plan and the intent of the ordinance being varied. LUBA specifically asked that the findings include citations to the comprehensive plan that promoted infill and higher density lots where appropriate in the city. The City Commission found that the comprehensive plan did promote infill and higher density, and the only lacking in the findings was a lack of citation to the sections of the comprehensive plan that do this. In the staff report addressing Criterion F, there is a citation to the growth and urbanization policy in the comprehensive plan, and the staff found that this section promotes infill and higher density and will promote the type of variance being requested by the applicant. The variance would allow 2 oversized lots to be developed with a mere 80-foot lot depth variance. In sum, it's not a huge difference from what is allowed outright in the code. And we'll still have an oversized lot, and it borders a street that's already in existence. So it's an excellent opportunity to use buildable vacant land in the city to add additional single-family residences without limiting or impacting the quality of life and the character of the neighborhood, of this older neighborhood where the property is located. Further, there's a housing policy in the comprehensive plan that promotes single-family residential housing. And this policy would also be evidence of the intent of the comprehensive plan to promote infill and higher density when appropriate. With this evidence, we can find that Criterion C Part 2 and Criterion F have been met, and the questions remanded back by LUBA can be amply answered by the evidence in the record existing today, as well as what I've introduced this afternoon. I do have some written materials that follow what I've stated today, and I'd like to submit them for the record.
Okay, and what exhibit did you want to mark that with? How about since we have letters, how about if we do a number, exhibit 1 or?
Sure.
What'd you say, 1?
Exhibit 1.
Exhibit 1?
Mm.
Thank you.
That concludes everything I had planned to present. It's rather simple and straightforward. There's only really 2 narrow issues to discuss at this time. Do you have any questions?
Commissioners, any questions?
Without, I haven't had a chance, obviously, to look at now Exhibit 1, but do you provide sites in the comprehensive plan to the two policies you referred to?
Yes, I do,
item
thank
F?
you.
Okay, so we can zero in on those.
Absolutely. I
You've
believe.
probably got enough time here, you might want to just say where those are a little more specifically.
Absolutely. The housing section is, I believe it's section C of the comprehensive plan. And the growth and urbanization.
Okay.
I don't know, is it?
Sorry about that. If you look on page 3 of Exhibit I, 1I. Quoted in the middle is the staff report findings regarding the policy 1 of the growth and urbanization section. And then further I talk about the housing policy, which is on page C16 of the comprehensive plan.
Okay. Thank you.
You're welcome.
Can I have my exhibit back, please?
Okay, any other questions from the commissioners this evening? Okay, well, thank you very much for your testimony. Mr. McKnight, did you have anything you wanted to add in? No. Okay. Alrighty, I don't have any yellow slips, but I know that Ms. Lord and, I forgot the other gentleman. Pardon?
Chairperson, we've got slips from Mark Regan and Linda Lord, and then Jim Hall asked to speak last. He's neither pro nor con.
Alrighty. Okay, who wanted to go first, Ms. Lord or Mr. Regan? And I would remind you that there would be a 5-minute timing on an individual testimony.
Okay, thank you. My name is Mark Reagan. I'm at 141 Barclay Avenue, Oregon City, which is right next to the lot in question. This has been going on a long time, and there's a lot of stuff going on, but if we're down to a couple narrow criteria here, a couple issues that I've picked up through this whole thing. I'm no attorney, I'm no land use person, but through the Planning Commission's original meetings and the planning staff report, and from the attorney originally all went to the city council, they all said that the criteria in C, when they talk about extraordinary circumstances, really applied to the land and not the circumstances. And there's a real interpretation of law there, and I don't know where that lands, but as it was brought up before, they didn't pass that because that does apply to the land and not to the circumstances.
That's right.
Okay. Secondly, if it is the circumstances, the item in question is as to whether he knew about these changes before it was time, in a timely manner, to get the whole thing done. The only testimony originally on that was his, and he said that he didn't have enough warning. Since then, we've been able to get a hold of Tamara DeRitter, and she did submit a letter stating that, from her recollection, there was plenty of time, and he was fully informed on this. And
Okay.
that's, I think the letters there should be in the record.
It was submitted to the plan, to the city last week. Was it forwarded to the
Not-
commission?
No, not in our application, or not in our packet. But if somebody could just read that for the record, that would be great.
Linda Lord. I don't. Do we have a copy of Chairperson, I have to apologize. I took this meeting over at the last minute, so
I
I don't have a
understand.
copy of that. If she would be willing to provide it to us, we could make copies and distribute right now. If you
Okay.
want to just take like a 2-minute
Sure.
recess, would that be okay?
I think that'd be a good
I
idea.
think you could go ahead and receive his testimony, and I can go make copies.
Okay, I can go on and come back to this if you want.
Okay, we'll get those copies made right now.
Okay, we do have a copy of it, right? Right.
she's going to provide one
Okay.
to us.
Okay, you may go ahead and continue, please.
Okay, and again, part of that same criteria C is whether or not there's a monetary hardship, and along those same lines, there's a letter in the record from Charlie Leeson, whose lot is directly in front of this, stating he has offered to buy the lot back multiple times. And so there is an alternative for this lot. It doesn't have to be made into a house. It doesn't have to, change the lay of the land there.
Can you say that again, please?
Yeah, the lot in question is behind.
Okay.
Well, I'd have to have a plan drawn, but it's behind Charlie Leeson's house. And he submitted a letter into the record, it should be in your packet also, that he has offered multiple times, all the way from beginning through as early as about 4 weeks ago, to buy the land back that was split off his lot originally. So there are alternatives for this land. It doesn't have to be.
Charlie Leeson sold the land originally?
Well, actually, what happened is Mr. McKnight bought the property, split it, and sold Charlie the front half of it. And Charlie's understanding was that he would have a right of first refusal if anything was going to happen to the back. And so that's why he wrote that letter in.
You don't have that much?
He's copying that also.
It's coming to him.
Apologize.
Okay, so that's kind of the specifics there. The last thing I'd like to talk about is how, and again, I've kind of walked through this whole thing, sitting back and watching, as it went through the planning commission and the planning staff and the city attorney, and actually there was even a quote from the planning commissioner at that time, Commissioner Hewitt, saying that a variance should be very difficult to obtain, otherwise why have ordinances? And what has happened since then, as it went to the city council, they kind of threw that out the window. And if you look at the LUBA findings, everything through the LUBA findings refers to a very permissive interpretation of the law. And the problem I have with that is this is the only variance in Oregon City that they're doing this very permissive interpretation of law. Everything else seems to be held to a very difficult standard. So it appears to me there's a different standard being held for different people in this, and that should be addressed, I think. Do you have any questions of me, or want to wait for the letters?
Just to clarify, I guess we don't have a map, do we, of the?
Yeah, it's in your
There
packet.
should be one in your
It's
packet.
I'm just looking for, that's okay. You're on one side of the property and
Thank you.
Charlie Leeson's on the other side of the property.
Yeah, my house, Charlie Leeson's house, Jim McKnight's house, and the lot in question is right behind Charlie Leeson's house.
Oh, so you're one house down.
It would be adjacent to my backyard is where this house would be built, so, yeah. So if you have the map there, I'm in, I'm in 5600. Charlie Leeson's 5500, and Jim McKnight's 5400, and you'll see Charlie Leeson's lot has been cut in half. So it's the back half of that. Oh, we have a different one. Yeah, so I'm in the one to the right that isn't really shown there, to my right, where the north-south marker is.
Okay, was there any other questions? Commissioner Bailey?
So are you suggesting that a permissive standard is overly permissive in the city commission's interpretation of criterion F?
Actually, in regards to everything that went to LUBA, as a matter of fact. But specifically, since we're talking about C in this case, it would be, the first half of C. F, I think, is a little clearer, it just needs to be cited. But again, the problem I have is with the whole thing that went to LUBA. If you read through their findings over and over again, in the findings, they say this is very permissive, but it's really up to the city council's interpretation, which is fine. I don't have a problem with that, but they don't interpret the same through all the variances. They've chosen to interpret differently on this one, and I have my own reasons why I think it might be, but, it's happened, so.
Any other questions? Okay, well, thank you very much for your testimony. I think we'll just take a couple minutes now and give the commission a chance to look over these two letters, and then we'll continue on with our testimony. On the back page at the bottom paragraph under verification, it says, please read the summary carefully and edit text to correct any errors and to clarify where appropriate. Please initial
Yes.
any changes. Who was doing that?
You may want to ask Ms. Lord when she comes forward to give her testimony. My interpretation, well, you may want to ask her rather than me trying to make a guess as to what it is. But
Okay, so it says, once the report is an accurate reflection of your memory, please sign and date below. I mean, it sounds like this document was not written by Tamara DeRitter herself. It sounds like it was written and edited and clarified and stuff.
Why don't we clarify that when Ms. Lord comes up?
Okay.
Right now, can I get you to accept onto the record the Tamara DeRitter affidavit, for lack of a better word, as Exhibit 2, and the Charlie Leeson letter as Exhibit 3.
Okay. Okay, then, I believe we're ready for Ms. Lord's testimony.
My name is Linda Lord. I live at 142 Holmes Lane in Oregon City. I am petitioner in Reagan v. Oregon City, the appeal of VR 9907 before LUBA. Before I begin my official 5 minutes, I'd like to respond to your question about the Tamara DeRitter letter. Being a paralegal, one of the techniques we learn is how to help a very busy person create information for decision makers that will be helpful for the decision when they say, I don't want to take the time to do that. This often happens with doctors and other professionals like Ms. DeRitter. Ms. DeRitter is the long-range planning manager for the city of Vancouver with a staff of 16 and has many, many evening meetings that she must attend. You can probably understand that. She was not available to be here in person, and so since her participation in the unusual history of the application is relevant to your decision, I made the effort to interview her, to do a fact investigation. I'm a paralegal. To do a fact investigation in order to get her memory of the event and record it. But I wanted to make sure, so I met with her in Vancouver. We had coffee. I talked to her about this situation and any history that she had that she could share. And asked her of her true memory, and then at the end of our discussion, I took notes, lots of notes, and then at the end of our discussion, I prepared the document that I then faxed to her. And I asked that she, as you read, that she look that over and make sure it was indeed a true and accurate representation of her best memory. This is akin to perpetuating an testimony in circuit court, but you're not circuit court, so instead of having a sworn affidavit, we have it this way because it was possible to do this way. I faxed the original to her, asked her to read it, and as you see, to initial, and she did initial wherever she made changes. She faxed it back to me. In the fax process, I noticed one letter in the one word in the margin, I think was on page 1, when she was talking about the, let me look. Yeah, one of the letters, or one of the words was washed out in the fax transmission, and it says, if I can see the beginning of that statement, looks like it's all one sentence, but the last word is, the last phrase is, as was customary practice by the planning department and city. The last word is city. So she faxed it back to me, signed, she had signed and dated it, faxed it back to me, and I provided a copy to Mr. Kobiasman for distribution to you on Tuesday morning. I made no changes to the text from what she had reported to me or from what she had written. It is her accurate testimony of the events of August 5th, 1998. Any other questions on the document?
Any questions? No. Okay, thank you.
I also have documents. And left them back here. Give you copies. So you can follow along with it. the city very kindly made these just before the meeting, since they were hot off the presses as of about 6:15 tonight. Do you want to distribute them then?
I was just gonna take one, but I'll have my here distribute.
How I'd like to use my time is to walk through this document so you see what's there. I'm not going to read every bit of it to you because it's too long for that. Most of it you're probably already familiar with. I'm just going to recap.
Okay, and we were going to be calling this Exhibit 4, I assume?
This would be Exhibit 4, thank you.
Does everyone have a copy?
Do you have a copy for the city attorney, please?
If you don't, I can follow along.
As long as I have a copy for me, that'll work. I do.
Thank you. Thanks.
Beginning on the first page, this addresses the issue in the procedural objection that was submitted, the second procedural objection that was submitted July 27th. This particular procedural objection has to do with equal protection, which is something that Mr. Reagan touched on lightly at the end of his conversation with you. The state law requires that all the criteria in place on the day the application was submitted must be used to evaluate the criteria. Also, the Oregon Constitution says that laws have to be applied equally. So my thought is that a variance process that approves a land use application, when that land use application has never been deliberated on by any authorized city body, is a failed process. It is a violation of the Constitution. My suggestion is, if for some reason you find that this proposal meets criteria C and F, the focus of tonight's agenda, that it's inappropriate for the city to continue its policy to grant the application, or its decision to grant the application, unless some city body has actually sat down and looked at whether or not this application meets criteria D, E, and F. No body has done that. The Planning Commission in April of last year never did it, and the City Commission never did it. The findings that were submitted by the applicant were essentially rubber stamped, or I won't say rubber stamped, were accepted without further comment or editing, I would put it that way, by the City Commission. So the City Commission never looked at D, E, and F, and someone needs to. If someone doesn't, then this is a violation of equal protection, and I think I stated that well enough, so I won't be told I didn't develop the argument fully at the local level. Even if you do reverse tonight, I still think we need to look at the process and make sure it doesn't happen again. On page 2, I begin my discussion of issues related to criteria C, the issue of hardship. I tell you there where you can find my various comments before. They're very well documented, and we can provide you with volumes of reading if that's what you prefer. Because I'm citing from the record, I ask that all the appellate briefs and audio tape of oral arguments at LUBA be added to the record in this matter. It's allowed by case law. If there's any question, I can provide you with a cite. Then I begin some brief review of what the applicant called his hardship. At the last Planning Commission meeting where this was discussed, I distributed a one-page document that had excerpts from both the reply to petitioner's response, or reply to, to the intervener's response to the petition. So in other words, the last things that they said to LUBA was that criteria C was met because of the unusual history of the application. The unusual history of the application has many facets. One of them is the fact that the hardships that the applicant said he had are, 1, a stroke, and 2, misinformation from Tamara DeRitter. We see in the findings of the city that the applicant unfortunately suffers from communication and comprehension problems. This was brought up in the petition, but nevertheless, no one ever asked Tamara DeRitter. I did, and you saw the result. She is unequivocally, absolutely positive that she gave him the information that was appropriate on August 5th, 1998. The city attorney suggested that perhaps she didn't know what the content of the proposed ordinance would be. We see from the legislative history of the ordinance that it was up for its final vote by City Commission that night. The text was well in place and had passed 2 hearings. She knew, and she told him. So we're page 3. We're going into what the city attorney told the City Commission after the Planning Commission's hearing in April. On page 4, beginning the 2nd paragraph, it begins City Attorney Sullivan's recommendations to the City Commission on the topic. He said that he recommends that you avoid the issues of who said what to whom in past conversations, but because of City Commission action, that is an issue before you now. In the summary, Mr. Sullivan wrote, this meaning the hardship issue, may be more difficult ground for the applicant to overcome, given the fact that the applicant has the right to build 1 but not 2 houses on the land. Applicant lost no rights. He does not have and did not have a right to build 2 houses on this land. He's asking for something outside of what the law allows him. Luba said intervener's ability to further divide tax lot 54 to create an additional parcel without a lot depth variance appears to fall within the prohibition in criterion C against granting variances to relieve a monetary hardship or inconvenience. That inability would certainly not qualify as a hardship, as that concept has been applied in considering variances. Luba, as Mr. Reagan mentioned, Luba noted the very permissive interpretation of criteria. This is the same message they said regarding criteria C, regarding extraordinary circumstances. Luba noted that no other city in the state has given such a liberal definition of what constitutes exceptional circumstances. Here we see that no other city in the state has given such a liberal interpretation to what constitutes hardship. Oregon City is not well served by such looseness in the application of our criteria. Your job, as you know, is the application of criteria to land use applications. It's appropriate to do it in this situation too. On page 5, I also
Ms. Lord, you're quite past your time, so are we close to summarizing?
Yes, we are. The intended ordinance, I did some research. The guy who wrote the first draft was City Attorney Dave Carnes. On page 6, 2nd paragraph, he talks about how he believes that this change in the underlying ordinance happened. On page 6, I also begin the issue of congruence with the comprehensive plan. I'd like to draw the Commission's attention to specific elements cited by the applicant. On page G4 and 5 in the comprehensive plan, at the top of G6, it is the city's policy to encourage small lot, single-family development in the low-density residential areas. That was spoken of by the applicant. However, you see that's only applying to the dual interest area agreement outside the city boundaries. It did not apply to established lots in established neighborhoods. Buildable lands in section C are identified as lots not substandard in size. This is a lot substandard in size or would need a variance. Section C also talks about maintaining the established characteristics of neighborhoods. And section G, if we want to look at it again, talks about the density in the city is not going up. It's maintaining the same as of the time that this was written, and I guess maybe I better find that and read it to you. It's on page G4. Projected average density per net acre in Oregon City's urban urban growth boundary is 8.93 units, and then it says the density would be increased by having smaller lot sizes in new subdivisions. The infill that the petition, this is the last point. The infill that the applicant says is good for the city is infill with substandard lots. The policy talks about infill of vacant land. This is not vacant land. This is developed land. Developed land that has, so developed that it has CCRs applied to it, that it is looked upon by the person who now owns the lot it was previously part of. It's desirous to him to be able to return his land to the configuration it was in when the subdivision was platted over 50 years ago. He wants it. The petition, or the applicant, agreed to sell it to him. What I think how this is relevant is the unusual history of the application. One of those elements is that the applicant never disclosed this information, that there is an alternative to this variance. He could simply sell the land to his next door neighbor who's written to you to acknowledge that he has a standing offer to purchase it at market value. This proposal is finally before you for, I'm hoping will be the last hearing. We entrust you with the best interests of the city and have faith that you will apply that in making this decision. Thank you so much for your time and your obvious dedication to your jobs. The fact that you read the material close enough to find that typo sure impressed the heck out of me. Thank you.
Thank you very much.
I have a couple of
Oh,
quick-
okay, I'm
quick-
sorry. I forgot to.
Ms. Lloyd,
do
there
the
may be some questions for you.
Ms. Lloyd, could you please? Yeah.
I'm sorry.
Just two real quick things. One is I want to remind my fellow people here, council, that when I made the motion last month in July to keep the record open until tonight, that we were very specific that we were only going to consider prong
C.
2 of criterion C and also F. And I noticed you didn't hear you refer to D and E and F, and I want to make sure that we kind of stay focused on those two, because that's what we agreed to do at our last meeting. And then last of all, I had just a quick question, and that is, I understand where Mr. McKnight's property is and Mr. What do we have? Mr. Reagan's property and Mr. Leeson's property, but on your address it says Holmes Lane. Are you representing Mr. Reagan, or are you
No.
interested in neighborhood? I guess I just was confused. Are you a neighbor?
I have responses to both of your points, and I'll answer the last one first.
Okay.
I am a member of the Land Use Subcommittee of Rivercrest Neighborhood Association, but the Land Use Subcommittee has taken the very specific position that the Neighborhood Association will not weigh in on either side of type 2 decision. If it was a type 3 and a type 4 that would be dealing with the change of zoning, for instance, the Neighborhood Association will take a stand. I personally am very interested in this because there is a CCR, which I understand the city does not enforce, but the deed restriction, as a member of the same subdivision affected by the same CCRs, I also have the right to enforce the CCRs. And I have informed, in fact, before applicant submitted his proposal, I informed him that if for some reason he's able to get through all the appeals I'm willing to take to LUBA and get a final decision on this variance proposal that would allow him to partition the land, I and a number of other neighbors are prepared to file a complaint in circuit court that will then also seek to enforce the CCR. So it's a long road.
Okay, that answers my question.
On
You mentioned a
DNF
couple of times that you were a paralegal, and so I was wondering if
I am a
you were
paralegal,
representing.
but no, I represent only myself.
Okay.
I'm not an attorney, and I cannot represent anyone but
That
me.
answers my question.
On D, E, and F, the reason I brought those issues to the city is, one, the constitutional question, because LUBA says you cannot waive constitutional rights, and this is a constitutional issue that.
And I wasn't asking a question about that. I was just
Okay.
reminding the fellow counselors here what we were talking about.
And ORS 174.10 requires that in applying a zoning law, the decision makers have to give effect to all parts of the ordinance, and that in fact is written in my page 7 of my written testimony. So even if you're not talking about D&E in your decision, the law requires you to give effect to all 6, not 5, but all 6 criteria.
Thank you.
You're welcome. Any other questions?
I just had a question about if you don't think that either the Planning Commission or the City Commission is an authoritative body to have heard the criteria and weighed in on whether this variance should be permitted or not permitted, who do you think is an authoritative body?
I do believe those are the 2 authoritative bodies. If you look at the commission meetings of both the Planning Commission and the City Commission, you will see that criteria D, E, and F were never discussed during those meetings.
All right, if that's your opinion.
I'd be happy to provide you the references in the record if you'd like to look at them now.
Okay, Mr. Bailey?
Are items D, E, and F, were they remanded by LUBA?
Yes.
LUBA said that they felt that D&E had been waived because they weren't specifically enough raised to the city. They said it's a very fine point, but they were going to weigh in on the city
But
side.
those were not remanded back to the city for findings, is that
D&E
correct?
was not were not remanded back to the city. F was, and so is C.
That's correct, so that's where I want to focus.
Okay. Any other questions? Okay, well, thank you.
Thanks for your time.
Okay, and I believe we have Mr. Hall waiting to give testimony.
Thank you, Madam Chairman, members of the commission. Rather an odd position for me this evening. I, as I indicated on the yellow slip, am neither pro nor con. And I come here this evening, unfortunately, kind of revealing my naivete. Last week, Ms. Lord called me at home. I wasn't there. Talked to my wife. My wife said, this lady wishes to talk to you about some history of the zoning ordinance, subdivision ordinance. That's fine. I was on the commission, as you know, for some years. I called her back. She wasn't home. She called me back. I wasn't home. This extended, I believe, 3 phone calls back and forth. I figured it was very, very important. I finally got a hold of her. Actually, she finally got a hold of me. And she identified herself and wanted to know about, in my opinion, a very obscure section of the ordinance. And wanted to know my knowledge of this. Well, the first question I had is, who are you and who do you represent? I'll talk to most anybody, but I want to know who you represent. She said she was chairman of the Land Use Committee for the Rivercrest neighborhood. Okay, that's fine. I have no problem with that. However, I have subsequently found out that's not true. If I had known it was just a citizen and was actually trying to grind an axe, I'm not sure I would have talked to her. Because I don't think what she was attempting to do was fair. There's a Ms. Patty Brown that I find out is the chairman of the Land Use Committee. Well, as a result of the continued questioning of me on this very obscure point of when a particular section of the ordinance was adopted and how it was adopted, I got my curiosity up. Somebody's after something. Somebody's got somebody they're trying to gore. I've been at this, as you people know, for some 40 years. I know about who's trying to gore who, and that after a while my stomach tells me the truth is not being told. Okay, I came to the city, and I had no idea what was going on, none whatsoever. But I walked into the city, and lo and behold, laying on the counter was this. I looked at it, and I thought, oops, there we are right there. So I did a little research. And I rather disparagingly refer to what's in this file and what I've heard tonight as one great, huge amount of balderdash. This is a matter, in my opinion, of attempting to throw as much against the wall as you possibly can throw and seeing what, if anything, will stick. We have two separate issues tonight, and there has been a whole plethora of nonsense on other things that has been thrown at you. One of which is the issue of how tough you make a variance. I believe Laura Surratt was on the commission one evening when we sat here and talked about a front yard variance. There was a boner by the city of 3 feet. I don't even know if you remember that, Ms. Surratt. Oh, yeah. Big deal. We granted it. Now, is that being overly liberal? I don't think so, particularly when the city screwed up. And I think that's exactly what we're talking about here. From what I can ascertain, Tamara DeRitter had a hearing, a pre-app hearing. Now, I sat through many, many, many different pre-app hearings. I find this form right here really totally inconclusive of what was discussed, except it does have on it that when it was applied for, and that it gave him some sort of vested right, and an extension, and all sorts of things. And when you talk about extension, you're talking about that which is before you at the time. If an extension was not applicable, if there was no extension given, you'd be coming under the criteria at the time that you then applied. I mean, again, I think what was being done here is throwing it against the wall and seeing how much can stick. I'm familiar with a piece of property. At this point in time, I live at 1006 Clearbrook. However, I also own a piece of property at 328 Ainsworth, which is about a block and a half from this particular piece of property. I've known of it for 35 years. And to say that the back ends of those properties are developed is nonsense. They are not. They are vacant. They're vacant land. CC&Rs that Mrs. Lord refers to, and I even did a little research on this. Where does she live? She lives in Rivercrest 2, not 1, but 2. She's not even in the same subdivision. The CC&Rs may be the same, but I've written a lot of CC&Rs, and I will apply the same CC&Rs in many instances to Carter's Edition, to Maine's Edition, to Surratt's Edition, and whatever. It's the same CC&Rs. It doesn't make it apply to number 1, though. She's not in privity of contract with Mr. McKnight. I have absolutely nothing to do with Mr. McKnight on this issue at all. But it does bug the devil out of me to have somebody call me and try to get me to say something that was incorrect and then pull this tonight. I don't like it. Now, in reference to the ordinance, can I have a drink of water?
Sure, please do.
Welcome to your first meeting. Lovely.
In reference to the ordinance provisions, we in the Planning Commission, I will be brutally frank about it, did not even begin to look at this obscure provision in there. I don't know how it got there. I have no idea whatsoever. What we were really focusing on was the planned unit development and making that thing more workable. We spent hour upon hour upon hour on that thing. Now, whether this is a mistake of Tamara DeRitter's, whether it's a mistake of Dan Cairns, whether it's our mistake, I don't know. But we, in my knowledge, and after Mrs. Lord talked to me, I went back and reviewed some things. I can't find any reference at all to our discussion of making this the inclusion within the ordinance. It was a mistake, in my opinion. But be that as it may, that's not the issue that's before you tonight. It's C and F. I think you should limit it to that. Thank you very much. Any questions?
Any questions, commissioners? Thank you very much.
There has been a request by the opponents, the applicants, to have an opportunity to rebut this material. I believe it's in your discretion to grant it, but you do not have to.
And what are we, okay. Okay, Ms. Lord, I'll give you opportunity to rebut, but I think we just need to limit it to about 2 minutes worth, if you can do it in
That
that.
should be enough. Telephone calls, hard to remember exact words, and I know exactly what I told him. I told him I was a member of the Land Use Subcommittee because he asked me why I was interested in the intent of the ordinance. That's one of the reasons why I'm interested, because it impacts not just this proposal, but all future proposals from the Neighborhood Association. He says I'm not a member of or not a resident with privy of contract to enforce the CCR. I'd be happy to provide you, in fact, would like the opportunity to keep the record open long enough to provide you with a copy of my deed and Mr. McKnight's deed, so you can see we're in the same subdivision. If Mr. Hall wishes to attack my credibility, he should give me some warning, and he should allow me to present a defense so that his misinterpretation of my behaviors do not become your final word on the topic. Thank you. And like I said, I have lots of documents. I also interviewed Jim Bean and Tamara DeRitter and Mr. Kearns, all with the same issue, trying to investigate the intent of the ordinance because the city's archives are missing. I went into the records as far as possible, but the City Planning Commission, the subcommittee work session notes are not in the city's archives. So I had to do oral histories. That was my requirement. That's all I could do in order to address this issue.
Okay. And let me assure you that the Planning Commission is capable of weighing in the evidence and making decisions based on our thoughts and feelings of the testimony that's been given. Okay, if there's no further testimony, then I believe that we are ready to close the public hearing.
I believe normally the applicant has an opportunity to provide final
okay.
rebuttal if they're interested.
Sorry. I always forget something.
Thank you. I'll be brief. I won't address any of the issues that have come up that don't pertain to criteria C, prong 2, and criterion F. If you have any questions about those, please feel free to ask, but I'll limit it to just C and F. There's been some discussion of Tamara DeRitter and the conversation with Mr. McKnight originally in the August 1998 meeting. I just asked the Planning Commission to keep in mind the fact that this is uncontested evidence in the record below. Luba specifically said there's substantial evidence in the record below and it's uncontested, and there's no reason to believe it's not the true fact. That testimony was given within a year of that meeting occurring. It was concurred with in the staff report that that was the content of the meeting in August 1998, and there was no testimony, written or oral, at any time in the Planning Commission hearings or the City Commission meetings that that was not the true representation of what occurred during that August 1998 meeting. There's also been some discussion of the comprehensive plan sections that I provided earlier. I'd like to first talk about the substandard size of this lot. It's not a substandard size in square footage. It's only substandard in lot depth. It's actually a 10,020 square foot lot. It's well within the character of the neighborhood that has oversized lots. This is an oversized lot. And that type of lot that maintains the quality and character of the neighborhood but provides more single-family residential housing is what is promoted by the comprehensive plan sections, both the housing section, where the policies and goals are stated on page C16, and the growth and urbanization section. Excuse me. Therefore, the comprehensive plan does provide two different sections that promote infill and higher density. It does not mean that all infill is good or appropriate, but in a case like this where the quality of the neighborhood will not be impaired in any way, that type of infill and higher density does comport with the comprehensive plan sections. And for those reasons, we ask that you affirm the decision of the City Commission and adopt findings addressing criterion C2 and criterion F.
Questions?
Any questions?
I do have a question of you or your, Mr. McKnight. What do you say about this letter from Charles Leeson? Is this your understanding?
I'd like to read it. I've never had a written offer or a verbal offer and an offer to purchase anything from Charlie. And it's in writing.
My client and I did speak about it during the hearing, and he said as he just said, he's never received any written offer. There's been limited conversations with his neighbor about purchase of the lot, and any conversations really that have occurred don't speak to either of the criterion. But even if there have been negotiations, there's certainly the right of the buyer and potential seller to come to a price that is mutually agreeable, and nothing like that has occurred. If you would like Mr. McKnight to talk about the letter now that he's had a chance to read it. Does that satisfy your question?
Okay, and also for the record, since we're talking about this right now, with Mr. Leeson's letter, I would like to state that Exhibit I in our packet has a petition with the subject being the variance, and we, the undersigned, recommend that you permit the applicant, Jim McKnight, to modify the zoning requirement, and Charles Leeson's signature is the first one on the line. So I just want to make sure that that is in the public record.
Thank you very much for bringing up that point.
Any other questions?
Thank you.
Okay, thank you very much. Well, I certainly would like to thank all of the people who have just, borne the longevity of this process on this variance. It's been a long and difficult and arduous situation for everyone. And there is an awful lot of stuff that has been sort of thrown at us that we have to wade through. And to wade through, there's a lot of issues, and we will stick to C and F and possibly address some side issues after we've done that. So for that, I will close the public hearing, and our planning commissioners will begin deliberation on this request. Mr. Bailey.
I would just ask the other members of the commission whether or not they would want to, I'm thinking procedure here, because these are two very different criteria to meet, two very different nexus of fact and decision-making, whether or not we can separate this into adopting them one at a time rather than trying to bundle the two different criteria. Go through and deal with item C first, and then item F.
I don't think that's procedurally correct. Mr. Kabizman can correct me on that. It's
procedurally, it really doesn't matter too much. I mean, the way things normally work is there's a motion on the floor. What this could be treated as is a motion to bifurcate C and E and then discuss what that is. There's no reason you can't do it that way. There's no reason that you're required to treat them both at the same time, but there's no reason you have to separate them. So it really is what makes sense to you analytically in your in how you want to discuss it. And it may be that some of you want to treat it one way and some of you want to treat it the other way,
I think there's some implicity that it would be good to discuss them one at a time, but when we get to a motion, they would be probably put into the motion together. Does that sound right? I think that sounds right to me.
That
That works. Okay. All righty. Well, who would like to start this evening? Nobody.
Well, I guess, if I may, Madam Chair, I've been around the planning business and public decision-making long enough to know that oftentimes meetings occur, discussions are held, and parties go away with radically different notions of what transpired, even with written notes. And so on the question I guess I'm going to say that I'm not necessarily impressed with trying to recreate the substance of discussions that took place a couple of years ago. Even parties that were involved can be, under discussing it from a certain point of view, misremember or misapply what went on. So I myself am going to more or less disregard that part of it and focus on the circumstances that item C seems to call for, whether or not this is a monetary hardship. And the second prong of it, of this issue, which is that this situation does not merely constitute a monetary hardship or inconvenience. And I think I myself have heard a lot of testimony that this is not about the financial hardship. It's not about the money. Public decision-making and sometimes getting cross-threaded in a public process of changing ordinances and plans and all of that sometimes does make a messy situation. And I think the Planning Commission, I mean, the fact that it's messy is evidenced by the fact that the Planning Commission kind of came down on it one way, and then the City Commission heard it another way. And I'm not going to second guess that myself. It's not as clear-cut as it might be, and I think everybody's entitled to kind of understand the broad discretion inherent in item C. I think F is far more specific, but item C, there's a lot of discretion there in how we interpret it. So I'm going to be pretty liberal in interpreting it myself.
Okay.
From the documentation that I have read, the property was bought with the intent of being able to subdivide under the guidelines that the city had given them at the time when it had started. So they got the information from the city. The property was bought with the knowledge that the city had at the time. Okay, knowing that it's a government entity and that items change in the government entity erratically, the property was bought for this purpose. Okay, so if you don't proceed with your partition or with your subdivision or with your building in a certain period in time, and you lose the window of opportunity because rules and regulations have gone through either environmental or fire codes or whatever, then to me, that's the hardship that you've created on yourself for not complying with the window of time that a governmental agency would allow. So I believe I read it a little bit differently, the information, than Commissioner Bailey.
Okay. Commissioner Duff? Did you weigh in?
Yeah, and if it comes down to that, whether the condition was self-imposed or not, I guess, you look at what is the window, he bought it in 91, the meeting was in 98, things were changed. I mean, it's a very close time frame there, when things were changed. I think you have to look at the intent, like you said. Mr. McKnight purchased the property with the intention of breaking off a lot. Was told that he could do that, and then things changed. Whether he was given the wrong information or not, I do agree that when LUBA reviewed this, that testimony was not. They said it was clear. There was no question about that, and that was not brought up at that time. And so I don't think it's correct to bring it up now, whether or not who said what, things like that, because I think it was clear. I think LUBA's come back to us and said, hey, there's these two issues. That's what we want you to look at. They didn't question anything in the record. I think it's easier, we can probably agree on F, in my opinion. criteria F. C is the one that's a little bit tricky, and, we may, out of 6 people here, have 6 different answers
right.
of
There's 8 different
what is
answers.
right, yeah, yeah. Because it does not say specifically.
Yeah.
Commissioner Orson?
Well, after listening to Mr. Hall's testimony, I feel a little differently about C, and I feel that Mr. McKnight bought the property with good intent. He did nothing devious about having a continuation. He wanted to develop the property, and the rules changed without him being notified of that, but he did apply for a continuance within that time frame, and I feel that we should consider that in the continuance, that, he should get the variance for that, within that time period, it went from 100 feet to 80 feet. Actually, I believe it was even less than 80 feet. 60
It was
feet,
60.
right, correct. So I guess I'm a little more lenient.
Okay, well, I guess it's my turn then on C. And I think sometimes the answer is in the details. And on the criteria C, prong 2, a self-imposed difficulty will be found if the applicant knew or should have known of the restriction at the time the site was purchased. When Mr. McKnight purchased the property in '91, the criteria was a minimum width or depth of not less than 60 feet. That was the criteria that was in existence at the time Mr. McKnight bought the property. I think that clearly suffices that number C is met. Also, if the issue of, well, I'm a little hesitant to bring other things into the discussion, although there's some other things that I just think are important. I guess I'll leave them till later. In my mind, that pretty well handles C. If he had purchased the property with the existing ordinance that requested a minimum of 80-foot depth, then he would surely not be able to qualify for the variance. The fact that the variance, a variance, we have to I'll divert for just a second here. A variance, the whole issue of a variance is because there are unusual circumstances. If there was not ever an unusual circumstance, we would never need a variance. So the terminology variance implies that we have to have some latitude in our ability to weigh in the evidence and whether a circumstance needs a little bit of a liberal reading of that variance, or if some other application needs a more stricter reading of that application. Unfortunately, as human beings, we live in the land of our opinions, and we try to come to a collective opinion based on all the evidence that comes in. And I think it's very important to keep that in mind, and what is the purpose of a variance right to begin with. And I really would like to go, if I could, to a couple things because I just think it's pertinent. I think it's terribly unfortunate that all of this has happened. It's been a big fall through the crack kind of a deal. And there's been a lot of talk about substandard lot. And I do not believe that a 10,000 20-foot square lot is a substandard lot. It is a standard lot, and there are actually in existence in the neighborhood many, many, many lots that are much smaller than that. I think that that supports the fact that this is not a substandard lot. It is unfortunate that our code, which I think Mr. Hall was alluding to, is written in a way that locks things into a minimum 100 by 80. Maybe that's an inappropriate way for that to be written. Maybe it should be based on overall lot size as opposed to lot dimension. I'm quite certain that if we were looking at a variance downtown, the lot size would be more in the 5,000 to 6,000 foot range, and what the dimensions of the lot are maybe not pertinent. In the covenants, the CC&Rs that have been referred to time and time again with all of this, there's a generic CC&R section in here that, let me find it here. I'm not sure where it came from. It's not headed or titled or anything. It's something I believe that Ms. Lord submitted that I do believe is generic. It's not the neighborhood's CC&Rs. They're talking about what covenants, conditions, and restrictions are supposed to be doing. And it says, if a landowner decides to subdivide a parcel, it makes the CC&Rs which run with the land applicable to whoever would be the new property owner. It does not say that you cannot subdivide a parcel. And when we go to the specific CC&Rs, it says on number 2, I won't read the whole thing, I'll just skip down to the last sentence, that no residential structure shall be erected or placed on any building plot which plot has an area of less than 7,500 square feet and not a width of less than 60 feet at the front building setback line. These are the neighborhood CC&Rs that have been brought into question time and time again. And I think it's clear in there that this lot would be well within the standard for the neighborhood. And that's about all I have to say, I think, with regard to criterion C. I don't, well, actually, I just have one more thing, and that would be echoing my fellow commissioners. It's absolutely not possible for the applicant to have known when he purchased the site that he would run into a change in the code. And because criteria C says that a self-imposed difficulty would be found if the applicant knew or should have known of the restriction at the time the site was purchased, that is very, very strong evidence to me. So do we have any other comments about criterion C?
I want to make a comment about the CC&Rs. I believe they're academical, as in the city would not reinforce them, at which point if Ms. Lord chooses to take action upon them, she may add it, but we would not need to incorporate them into our thought tonight.
That is correct. The CC&Rs are basically private contracts between the homeowners within the subdivision. They're not something that the city enforces. We may require them from time to time.
Okay, so then I guess we would be ready to go on to our deliberation of criterion F.
I have a question of the city attorney.
Sure.
I'm struggling with how to weigh the various sections of the comprehensive plan there are general goals that talk about infill, et cetera, as have been quoted this evening. And then there's a specific zoning for various areas of the city. What does case law say? How should we look at that? How should we weigh that?
Case law basically says cities have a lot of discretion about how they want to weigh and interpret it and say what is important and what has more weight than others. In the comprehensive plan, there's inevitably conflicts. There's a preservation. You want to preserve green spaces, but you want to have industrial land. You want to keep, and to the extent you say, we're only going to follow the green spaces one, you're going right in the face of the industrial land. And it's that balance that you as a decision makers are really supposed to make. You can't ignore any of them. You can't interpret ones to say something that it doesn't say. But other than that, that's really your role is to balance and weigh them in the way that makes sense to you and that makes sense in terms of the entire comprehensive plan. I know that's really not much of an answer and may not provide much help, but that's what the case law says.
Commissioners, any comments on F?
I feel pretty comfortable with F, that the criterion has been met. I think it was more of a procedural thing where maybe it wasn't specifically identified originally, where it is in the comprehensive plan. Maybe we didn't refer back to the specific point, but I think there again, I think the intent of the comprehensive plan is to encourage infill where it does not change the character of the neighborhood. And to me, I think criterion F has been met.
I'll echo Commissioner Main's feelings.
Mr. Bailey?
I would agree in general, but I was wondering, Commissioner Main, if you have some specific policies
I do.
that you are referring to.
I do. Okay.
I think they were brought up this evening.
Yeah.
I think Mrs. Long.
Okay. I'm looking at
Referred 'em back to
some
the-
here, but we need to look at the
Right.
exact ones. So.
Okay. Well, I'll jump in here then. With this, I think that the Chapter 17.64, the planned unit development, really identifies what we're talking about here. And I do believe that if there was such a thing as a planned unit development at the time Rivercrest was built, then that certainly would be a planned unit development because it fits all of the criteria. The purpose of a planned unit development is a form of residential land development that allows increased flexibility in design standards, dimensional requirements, and mixes of land use and structure types. A PUD should allow for a more customized design and development through a process that involves a public hearing before the Planning Commission at the preliminary plan stage. And I'm going to just read some of this because I do think it's pertinent. The purpose is to promote an arrangement of land uses, lot sizes, lotting patterns, housing and development types, buildings, circulation systems, etc. The objective is to provide an integrated urban community whereby each of the parts complement one another. The way that this neighborhood fits into this also is because it preserves existing natural features and amenities and provides useful common open space to the residents. We have that beautiful Rivercrest Park. To protect and enhance public safety on sites with developmental constraints through clustering of development on those portions of a site that are suitable for development, and to provide flexibility for dimensional requirements of underlying zones or overlay districts to better achieve the purposes of a PUD. And to my way of thinking, as I mentioned, I think that the Rivercrest neighborhood is certainly fits the description and the purpose of a planned unit development. The planned unit development is most certainly part of our comprehensive plan, And I believe it fully satisfies the criterion F to be supported by Chapter 17.64 in our planned unit development purpose and criteria. And I think that a lot such as this fits very nicely into the intent of development patterns, clustering. The lot size is not a substandard lot size. It is a standard lot size. It faces onto the street. It's not harming anybody or anything. And another very important and pertinent fact to me about this situation is that we have not had the neighborhood here objecting. All the time when we have our hearings, both Planning Commission and City Commission, when the neighborhoods feel very strongly about something, they are here in mass and they are very, very vocal, and their opinion weighs in very, very strongly with us, and we take it very seriously. And the fact that the neighborhood is very distinctly missing in this variance proceeding would lead me to believe that they have no objection to this variance. I believe that it does meet the criteria. The criteria, again, if we have been a little bit liberal in our discussion of how the criteria fits, I think this just happens to be a very unique occasion whereby with things that fell through the crack, the timing of new ordinances, the timing of issues not being followed through as appropriately as they could have. There's all kinds of situations that have occurred with this that have made it very, very difficult. And I'm sorry that it's been such a difficult thing, and I hope that we don't have to go through this with anyone else to receive a variance. Is there any other discussion?
I would like it noted for the record that on Exhibit 4 that Linda Lord had submitted, that if C and F are met, and those are what we are deciding on tonight, okay. My discussion was on D, and I'm very disappointed that I didn't get the opportunity to discuss that because I am cited on page 8, so there was discussion of D. Thank you.
Thank you. Well then, if we have no further deliberation, are we ready to make a motion? Mr. Bailey.
I was just going to, I had not looked quite so closely at the PUD elements of the plan, but I've been rather looking at the urban growth policies. And I'm not sure quite where we are on the plan document itself, and I'm referring to the one that I was issued when I signed on this ship, which is dated originally from 1982, but has been updated periodically. And I'm looking at the overall policies in the growth and urbanization goals and policies section. And on page G7 of that original document, and they may have been updated beyond that I have not found, but I'm also seeing that the urban growth policy number 1 to accommodate the projected growth, I think is an element, and in doing it with that this particular action can help meet that goal and that policy and do it in a way that does not violate either, as you said, Madam Chairman, the character of the neighborhood. It's not creating a substandard lot other than in one dimension. It makes full use of the services, which is also called for in the urban growth policies, and makes much more efficient use of the existing facilities and services that the city already has. So I would also reference the urbanization and growth policies of the comprehensive plan.
Okay, very good. And I think if there's any doubt still remaining, it seems to me that we have to always come back and ask that one last question, and that question being, what is in the best interest of the city? Because after all, that's what we, as a planning commission, are here to do, is to look out for what's in the best interest of the city. And I do believe that we have documented that our city does intend to do an appropriate job of development where we can, and it's in the best interest of the city to be able to utilize an infill property that is available without having expensive infrastructure to go on. It's appropriate for the city to be able to gain a property that's a tax-paying property without having to fork over a bunch of money to get the roads and the sewers and all the infrastructure additionally in place. It's already in place, it's already paid for. If there was anything about this lot that was substandard or anything about it that would be detrimental to the neighborhood, the neighbor would be here telling us that it was detrimental. If there was anything whatsoever about it that seemed potentially negative or harmful or disadvantageous in any way, I'm certain the Planning Commission would be weighing in on that very, very heavily. That just doesn't seem to be here with CNF. Criterion CNF and with the variance application itself overall. Right. I'm not doing that. Trying not to. So, are we ready to make a motion now?
Sure. I will. I move that we accept these findings for the file number VR 99-07, remand of LUBA 2000-125, city application 00-3, James McKnight at 161 Barclay Avenue. I believe that criteria C and F have been met, and that the variance granted by the planning, should be granted by the Planning Commission.
Can I clarify that? Because what I think I heard you say was that you're denying the appeal, approving the variance, and directing the applicant's attorney to develop findings that they will be then passed on to our city attorney for review and brought back to you at a later date.
Right.
No, that's not my intention.
Okay.
Okay.
Don't we have our own findings? I mean, isn't this
Uh,
it? Isn't our deliberation finding?
Yes.
The deliberations are findings, but they should be reduced to writing, and I would think somebody needs
Oh.
to go and we don't have any written findings that are in front of you for your review. What we'd suggest you do is that the findings that you've made tonight be reduced to writing and brought back for your review.
And city staff can,
City staff can certainly do that. The normal.
or the applicant's attorney.
We prefer that the applicant's attorney do that and then bring them back to our city attorney for review, and then we bring them back to you once we're comfortable with it.
It's a matter of efficient use of city resources.
Okay.
Okay.
See, and I forgot all that part of it too.
That's right. Thank you.
Carter, may I also request that the planning commission make a finding on the procedural objections regarding D&E so it can be appealed?
No. You have a motion on the floor right now, so let's just go ahead and deal with that, okay?
The other commissioners clear now with what my motion was? Do I need to restate it?
Would you like me to restate your motion?
Please
or-
do.
Yeah, would you?
We love clarity.
Commissioner Main, I believe, made the motion to deny appeal number 00-03 and approve variance 99-07 and direct the applicant's attorney to work with our city attorney to develop written findings to be brought back forth to the planning commission at a later date.
That is-
Or if you prefer a date certain.
I prefer a date certain.
Okay, then we would have to ask the applicant's attorney at this point what kind of time she needs.
In addition, I think we're going to have to wait till the minutes from this meeting are prepared so that we can have those available to review in the preparation of the findings. So
That
that
would be
may
right.
stretch it a little bit further as well.
Okay. Well, if you want to go a date certain, our minute takers here, so.
Well, I think we'll need to go to the second meeting in September.
Yes.
I was going to recommend that. Would that be okay?
Oh, sure.
Okay, so September 20th, I believe. Is that the 20th?
24th.
24th.
Okay, September 24th should be sufficient time to do all the,
Is that all right? And then in the minutes will be adopted then?
The minutes will actually be should be ready. They won't be adopted till the next meeting, but
They'll be
we should have
draft
them ready
minutes.
pretty
So
quick.
we'll provide on September
24th.
well, we'll need them, we'll need them before that.
For adoption for the meeting of September 10th, so that they will be official as of
Okay.
September 10th, correct?
Correct.
Well, in the event that we don't happen to have a public hearing on September 10th, that might,
No, what I'm saying, ma'am, is that the minutes will be then in official form, approved form.
Once you adopt it.
For her to work off of, to
Oh.
prepare for the meeting on the
there,
24th.
there may be a situation if there are no applications or some other, you don't have a quorum, we may not have official minutes at that time, but I think the draft minutes should be more than sufficient for us to understand the
Okay.
gist of your comments. And if it
Okay.
isn't, we can certainly take the findings that you look at on the 24th and
okay,
amend them further.
okay.
So.
And since our minutes are usually very, very near perfect correctness, I don't think we'll be worried about it.
Okay, so we will need, just to clarify with the applicant's attorney, we will need those minutes, I would say at least 10 days prior to the 24th, so the 14th, and that has to leave in time for review and comment between the two attorneys. Okay? Thanks.
Okay, so we have a motion. Do we have a second?
I'll second the motion.
We have a motion with a second. Please poll the commission.
Seconded by Commissioner Orson. Okay.
Yes.
I'm sorry, I'm not as fast as Maggie. Commissioner Bailey,
Aye.
Chairperson Carter,
Aye.
Commissioner Main,
Aye.
Commissioner Mengelberg,
Aye.
Commissioner Orson,
Aye.
Commissioner Surratt.
Aye.
Okay, great.
Well, thank you very, very much. I'm sorry that not all parties can, be accommodated, that not everyone can get what they want, and
Just to request a decision on the procedural objection by the planning commission.
No, it's out of
We'll have
order.
the findings ready for you on the 24th.
okay, thank you. Okay, do we want to take a short recess, or should we just
It's
go
up to
through
you.
and finish it up?
This is going to be a
Let's-
very
yeah.
short agenda.
Okay.
Do you want a short break?
Let's do it for just a.
Let's do it.
I
Let's
need
do a
a drink
2-minute
of water
recess.
and
Okay.
stuff.
Back in session.
But- Okay, I think we're ready to continue then, and my understanding is that we are going to be asking for a continuance of CU 01-02, City of Oregon City, conditional use for the creation of the new Amtrak station and parking lot. Did you wish to address that?
That's my staff presentation. If you have any questions, Nancy Krushower is here to answer any that you might have about the project or about the application itself. Nancy Krushower, if you don't know, is our city engineer.
Mr. Bailey?
Madam Chairman, if I may take a moment of time here, I was intrigued by the drawings that I saw. Is it, and the reuse of the old freight depot? Is that what's happening?
That's
Here?
what we're going to attempt to.
Try to do that?
complete. Correct.
Okay. And it's being built on a platform that's above the flood
Floodplain,
level, as it were?
correct.
And eventually there will be a cool little clock tower, sort of like
Eventually.
Union Station?
Eventually.
Eventually. Okay, so where is said depot now?
Said depot is an existing office building about, what, 80 yards from the site?
So that is
That's the original depot.
Okay. I've seen it, and I looked at it and thought, is that what it's gonna be? Okay. And that's the one that was across the street from where the barber shop is, kinda down in
Mhm.
that area?
Correct.
Originally, okay. Well, good.
Okay.
I would only have one request, and that perhaps we try to select a date for the next public hearing, because
September 10th.
the applicant is getting concerned about not getting this public hearing completed, and so,
The applicant?
the applicant, yes.
That would be
the city?
Ms. Crush Hour.
Ah.
She is an agent of the city.
Right.
And so I would recommend that we set this for public hearing on September 10th, if you're amenable to that.
Does she need a deadline? Is that what you're saying?
Well,
Is
it's-
that going to be, I need to ask the planning staff if
Is
that's
that
going to be possible, because the problem has been that the planning staff has absolutely understandably, due to lack of resources, not been able to
Why don't
complete
we-
I
staff
think we need to
report.
go to the.
tweak that to the 24th.
Right.
Okay.
And then we'll make sure that the proper notification and all occurs as
Right.
well.
Okay. So date certain of September 24th.
September
Thank you.
For continuance of DR 99, or CU 01-02.
Thank you very much.
Okay,
It
great.
would come easier.
May I
from
ask
your
one more
lips than
question
mine.
before we vote on continuing this matter, which I'm assuming will be unanimous? And that is the status of negotiations or noises by the railroad to try to get, to close the access across on, what's the street?
17th.
17th, yes. What's happening with
Well,
that?
we've completed the revised traffic impact study, and that will be included in the packet that this planning staff gets to you for the hearing. And what I understand from the revised traffic impact study reviewing what the effects of closing 17th Street are is that the city, although it's desirable to keep a connection between end of the trail area and the Clackamas Cove area and Main Street, it's not vital from a traffic standpoint. And the impacts are mitigable without
Okay.
much difficulty at all. So we are able to close 17th Street, although it's not desirable in terms of meeting TSP goals and policies, and certainly in just providing great multimodal connectivity. But it's also my understanding that having the Amtrak station be part of this community will provide so many benefits that you have to find a balance. And so for that reason, we would not try to continue to challenge the railroad on closing 17th Street.
TSP is a transportation system
Right.
plan, in case you didn't.
Can I continue on that vein of diversion? That is, your projections that it might not be needed is also based on the development of the Home Depot and potential future development of what is now the Gulf driving range, and also the potential development of Clackamas
Right.
Cove with housing and office and so
Yeah,
on.
quite frankly, the transportation system plan still shows the need for a connection. But you have to start looking at like I said, that you have to find a balance, and the connection still could be possible to have an overcrossing of the railroad tracks. That, to me, economically, for the city, is not realistic, and also from an aesthetic standpoint, it's not very practical. So that's when you start looking at other options, and your traffic impact study will address the impacts of growth. It'll look at a 20-year study, and it will tell you where the impacts on other local intersections will be. And I believe the findings from that study are that they're not so great, that they can't be solved with signal improvements, with adding right turn lanes and the like.
Think of the siting of the depot like balancing comprehensive plan goals. And that should
It's-
help you somewhat, because it's much like that. We're dealing with
Yeah.
political, we're dealing with the railroad, and railroads.
And
are-
geography, you've got 205 sitting right there in the middle of the world. If 205 wasn't there, it would be easier to do undercrossing, overcrossing, whatever. But to meet all of the grades in that area, I'm not sure if any of you have followed any of the Abernathy Creek Bridge project, but we did a pretty thorough investigation of moving the Washington Street, Abernathy 17th Street intersection to the north, and what that would mean. And it wasn't very pretty. And then financially, I mean, it's the kind of project that I don't think I would ever recommend for the city at this point, unless millions and millions of dollars were found and you could do it so that you wouldn't have such a negative impact on that area.
Well, I think that's good news, actually. I'm glad to hear that it went that way. So,
Thank you.
okay, then I guess we're ready for a motion to continue.
The
Does someone
motion.
like to make it?
Thank you.
How about if I move that we continue applicant CU 101-02, that was a correction there at the beginning, for the Amtrak project till date certain September 24th?
I'd second that.
Okay, we have a motion with a second. Please poll the commission.
Commissioner Bailey,
Aye.
Chairperson Carter,
Aye.
Commissioner Main,
Aye.
Commissioner Mengelberg,
Aye.
Commissioner Orzen,
Aye.
Commissioner Surratt.
Aye.
Thank you.
Okay, Mr. Cosgrove, thank you, Nancy. Mr. Cosgrove, did you have any old business that you wanted to discuss this evening?
I don't have any old business. I'll be happy to answer any questions that you have, but I don't have anything new to add, or old, actually.
Nothing new, nothing old? Okay, any comments by my commissioners tonight?
I'm sorry, I do have one thing. You do know that we have 2 new planning staff members.
We've heard that.
Okay, great.
Haven't.
You didn't know?
No.
Oh, okay. Well, we do have 2 new assistant planners that will be helping Sean. I'm not sure how Maggie has it set up as far as allocating files and workload and all that, but I'm sure she'll be glad to fill you in on that when she gets back. And also, we're recruiting right now for a senior planner, so hopefully at full staff, we'll have 3 assistants and a senior planner and Maggie, so we can start going on some of this long-range stuff, which just been put off and put off and put off. So we're just dealing with files right now, so we hope to get to that long-range stuff.
So is the decision, instead of having 2 senior planners, to replace one of the senior planners with 2 assistants?
Right. We need, at this point, we need more worker bees and, more Indians and less chiefs, or however they said that in the Army when I was in 15 years ago. Yeah, so.
Okay.
Good news.
That is very good news. And I would like to assure, everybody out there that I believe that our planning department is very adeptly managed by Ms. Collins and our Assistant City Manager, Mr. Cosgrove, and problems that we have encountered in the recent past. Hopefully, we will not be encountering things like that in the future now. So, any other, Mr. Bailey?
I'd just like to echo that. In my professional life, I'm exposed to a lot of different planning staffs around the state and city administrations and that kind of thing. And this is arguably one of the best I've seen. So I really appreciate the work they do, and especially shorthanded as you all have been over the last month or 6 months or 6 years or however long it's been. So
I used to walk into the
thanks so
planning
much.
division every morning and say, I'd like to introduce my planning division.
And poor Sean Cook, he doesn't get any accolades, but he's been slugging through the trenches all this time as well. So, Mr. Cook, you deserve a round of applause
Yeah,
also.
it's critical, absolutely.
So, well, having said that, this is the time of the month where I do my little bit for Toast and Topics, which is going to be August 31st. That is the Chamber of Commerce event that is an open forum breakfast discussion about issues that affect Oregon City. And we did just get a bit of an update from Ms. Crushhour about the train depot, but we will be discussing that on Friday, and that's this Friday. And we will also be discussing the new Malala Improvement Plan, which will be coming down the pike very shortly now. So for those of you who would like to join us for all-you-can-eat breakfast, $10 at the Rivershore Hotel, please do so. We begin our meeting at 7:45, and we encourage participation by the public and the business community and anyone who would be interested in having discussion, open discussion, and hearing about what's going on in Oregon City that's pertinent.
Great.
And I would like to thank my fellow commissioners for such a good job tonight under adverse circumstances. I think this was hopefully one of the hardest things that we'll ever have to encounter. So, all in favor of meeting adjourned?
Aye.
Aye.
So moved.